Let's talk about trust and grandchildren or friends and other relatives. On somewhat of regular occasion, after someone passes away and has left behind their estate in a trust, the trustee will get a request or perhaps a demand from one of the friends or family members for a copy of the trust instrument, the document that created the trust, that is. Often the trustee is reluctant to deliver up a copy of that trust, perhaps because this person does not inherit under the trust. So let's talk a little bit about it. Generally speaking, if the person making the request for a copy of the trust is an heir at law, that means they would inherit in the absence of a trust or will, then that person is probably going to be entitled to receive a copy of the trust. On the other hand, if the person making the request is not an heir at law, for example, the daughter-in-law of the decedent would not be an heir at law. If the person requesting the trust is not an heir at law, generally the judge will not give them a copy of the trust. There are many exceptions to that general rule, but generally people who are not heirs at law will not be entitled to a copy of the trust unless they receive under the trust. I can hear you say, wait, what if they do receive something under the trust? Do I then have to give them a copy of the trust? My answer is, I do not know of any statute that requires trustee to give the beneficiary a copy of the trust. But as a practical matter, you can be absolutely sure that the beneficiaries under the trust would be able to get a court order requiring the trustee to deliver up a copy of the trust. This is necessary because under the state statutes in Oklahoma, the beneficiary has a right to demand an accounting of the trustee to assure that he or she is receiving what the trust says they're entitled to receive. It's going to be difficult, perhaps impossible, to determine whether the trustee has delivered up the correct gift without reviewing the trust itself. Therefore, if someone is named in the trust, I would suggest to you that the best decision is to allow them to have a copy of the trust. If they were to file a lawsuit requesting a court order for a copy of the trust, the judge would require you to deliver it. Given that fact, I don't think there's any point in attempting to hide the trust. Outside of the people who receive under the trust, and outside of the people who would inherit from the decedent if he or she did not have a will or trust, there's not going to be many people who have the right to demand and receive a copy of the trust. There is a reasonable chance that a state agency could ask for a trust and be entitled to receive it. I've not seen that happen where the request comes after the death of the beneficiary or after the death of the trustor, but it could, and the state agency could be entitled to receive it. It would be a case-by-case basis. As a general rule, if someone asks for a copy of the trust after the trustor has passed away, you're going to be hard-pressed to convince a judge that that is a secret document that should not be delivered to that person. Now, the terms of the trust may require or allow the trustee to retain possession of the trust and only deliver up those portions of the trust that relate to that particular person. There is a chance, but not a certainty, there is a chance that the court would honor that trust provision and allow the trustee to only deliver up the portion of the trust that relates to the person making the request. I would suggest to you that there's a good chance that the court would require that the entire trust document be delivered up. And that is because the person making the request may wish to bring a claim that the trust is invalid. It is likely that the courts would find that it is in the best interest of justice that everyone be allowed to look at the trust document and make an independent determination as to whether they believe it to be a valid trust document. I'm not certain that that will be the outcome in every case, but I believe it's more likely than not that that's what the court would decide. Now that doesn't mean you need to go around handing out copies of the trustor's trust document to everyone who you think might someday want to see one. That's not the case. It defeats the part of the purpose of having a trust, which is maintaining your privacy. So use some wisdom. If someone is likely to be entitled to receive a copy of the trust, if they ask the court for it, go ahead and give them a copy. Or at least give them a copy of the terms of the trust that relate to them. If he has specific trust questions, we'd be happy to hear from you. And if you'd like to come to one of our estate planning workshops, please call us to make an appointment. 405-733-8686. There are no selling opportunities at the workshop. We're just there to deliver information. I do hope you'll come back and consider using us for your estate planning, but that won't happen at the workshop. The workshop is just a time for you to learn about estate planning. Thank you for watching. We look forward to seeing you in person.